So, Mr. Geiser, your arguments are better for the government's first argument. But if you go to the government's backup argument and say that they can only dismiss once they've intervened, even if that intervention follows an initial declining of the opportunity, then most of your arguments fall away. On that theory, it makes perfect sense to, well, the intervention kicks you back to 1, which gets you into 2A.
Your Honor, I do agree that a lot of our arguments are designed to show the government at least has to intervene first and satisfy that good cause showing. But we still have, I think, at least 2 or 3 important arguments, even to show that that sort of reset the case argument doesn't work. The first, again, is it says you can intervene. It does not say intervene and proceed with the action. Congress used that different terminology in B2. And when Congress put the government to the choice of taking over the case, not just intervening and participating, but taking it over, they always use the phrase proceed with the action. It's a very distinctive phrase, and it's repeated throughout the False Claims Act. The second point, again, is that this is still limiting the relator's status and rights. It says you can intervene, government, but you cannot limit the relator's status and rights.
Well, it says the court shouldn't limit the status and rights. That's a different thing.
Well, it does, but I think, though, that in paragraph 2, none of those rights are activated unless the court is doing it. So the court then is limiting the relator's status and rights. And by just right on the face of the statute, paragraph 2, again, if you look to C1, Congress described the rights in C2, those restrictions, as limitations on the relator's participation. So that is quite clearly a limit on the relator's status and rights. And this is also inconsistent with the broader structure of the Act. Look back to the initial choice that the government makes. That's under subsection B. That has to happen at the outset of the case. It says the government has to decide whether to proceed with the action or not within the first 60-day period, extended by months and often years. There's nothing in subsection C, and it would be a very odd way for Congress to have written this, to say subsection C, when the government intervenes, even though we're not saying intervene and proceed with the action, and even though we're not saying just intervene and without limiting the relator's status and rights, we have that qualifier in there, that Congress thought that the government at that point could reset the party's rights, effectively restart the litigation. If you look at 3731, C, the government has the right, if they do intervene and proceed with the action, to file a new complaint. They can basically start the case over years down the road, which isn't good for the relator and it's not good for the private defendant.